Good afternoon, everyone, and thank you for attending today's webinar. My name is Claire Barton, and I will be your host. This webinar is brought to you by the Chartered Governance Institute of Canada, the only global qualifying organization in Canada where you can become a chartered governance professional. For further information about our programs, membership, and upcoming events, I invite you to visit our website at www.cgiofcanada.ca. Today's webinar is entitled Conflicts of Interest in the Boardroom. Let's talk about it. And our guest speakers are Maria Capozzi and Andrew Buck. Maria Capozzi is a fellow of CGIC. She holds a Master of Public Administration and is a certified government auditing professional from the Institute of Internal Auditors. Maria has conducted governance audits, reviews, and assessments of boards of directors in the public sector. She has recently retired from Manitoba's Office of the Auditor General, where she served as a director of its governance practice. Andrew Buck received his law degree from the University of Manitoba and has a business law practice at Pitblado Law. He provides advice to private and public sector organizations regarding corporate governance issues. He has also assisted public sector organizations with the creation and implementation of conflict of interest policies. Before we begin our presentation, please note that everyone has been muted, but if you have any questions, just type them in the chat line and we will be sure to address those. And with that, I would like to turn over the presentation to our guest speakers.
Thank you, Claire. Hello, everyone. I'm really pleased to be part of the panel today to discuss conflicts of interest and how they're managed in the boardroom, because I know that there is room for improvement. My work in conducting governance audits and reviews over the past 24 years with Manitoba's Office of the Auditor General has given me the rare privilege, the opportunity to see behind the scenes at how boards really function and how conflict of interest issues are handled. Also, it's an opportunity to review many different policies and practices. And I've also had the very good privilege of interviewing many board members over the years. Whenever we conduct a governance audit, we meet with each board member individually to talk about board issues, as well as any concerns that they may have had on the board. And one of the topics that arises repeatedly is around conflicts of interest. So often board members tell me that they have felt uncomfortable with how a conflict of interest was handled, or in fact not handled by them. And they were unsure of what to do, and they felt really awkward raising it in the moment in the boardroom. And I've also had chairs share with me some of the challenges that they've experienced with in discussing conflict of interest with board members, and just how difficult that can be. So I believe it's really important that we start to change the conversation around conflict of interest and talk about it openly at the board table. Because up until now, having conflict of interest has been treated as such a negative, judgment-laden issue, something that has to be handled delicately or secretively. It's like if you have a conflict of interest, you're a bad board member. So I truly believe that it's time to take away the negativity and remove that stigma. It's not about the individual board member or their quality as a board member, how effective they are as a board member, because every single one of us at a board table has conflicts of interest. All board members bring their professional and personal involvements, both paid and voluntary. We bring all of our previous board experience, our previous organizational experience, and we also bring the variety of personal and professional connections that we have to their board role, We come as a whole person. So these attributes are actually usually the valued attributes that are the very reason why we were asked to serve on this board. So the potential exists that at some point during your tenure on the board, a conflict of interest may arise. So for any member, so when these conflicts arise, it's simply a topic that should be discussed by the board in an open and transparent manner so that actions can be taken to manage it appropriately and ensure we demonstrate the board's due diligence in order to protect the integrity of the board's decision making. So one of the things that's really stood out for me when talking to board members in our audits is that we as individuals often don't really recognize that a perception of conflict may exist. Um, we don't see that we have a conflict, probably potentially because it's not an actual conflict, but also we just don't see it because, I'm not a bad board member. I'm a good board member and I can be independent minded. You feel really kind of put off that you might imply that I can't be independent or conflict free. And but what we don't always recognize as individuals is that those around the table, our fellow board members, may perceive a conflict to exist for us because they may not know all of your involvement or know the details of your involvement. So that perception could exist, and it's very awkward around the table. No one wants to be impolite. It's very hard to raise it in the moment. And also, no one wants to imply something untoward with our fellow board. Usually we like and respect our fellow board members, so we're very leery to imply that anything untoward is happening. But here's what happens. I might turn to one of the other board members. So this is what happens. This can be a parking lot conversation, or it could just be the slight moment in the board meeting where I kind of lean back and I kind of say to my fellow, doesn't that person's spouse work at that company? And shouldn't they have declared a conflict there? And my fellow board member goes, yeah, I know, I thought the same thing. And right there's subtle seeds of doubt and a subtle dysfunctionality that starts to creep in. And then what I found talking to board members is that board members keep score. So now later, say my spouse is an engineer, works with a big firm that is doing projects for this particular organization. And I think to myself, well, I'm not involved in my husband's firm or what they do. My husband's not involved in the bidding or project selection for that firm. So I'm not in a conflict. And besides, when that person's spouse's company was discussed, they didn't declare a conflict of interest. I certainly don't have to. And that's how that subtle dysfunctionality starts to get baked in and just becomes kind of how the board functions in practice. So before we can start talking about how to improve board practices, I'm going to turn it over to my colleague, Andrew Buck, to tell us from a legal perspective, what is a conflict of interest and give some examples, and as well as the sources of duties for directors.
Thank you very much, Maria, and thank you, Claire, for the introduction. Thanks, everyone, for joining. I think I'm going to initially talk about, as Maria said, where well, first of all, try and provide you a definition of what a conflict of interest is, and then give you a sense of if you were to come to someone like me for a legal opinion about, geez, is there a conflict of interest and what are we supposed to do? The first thing I'm going to do is I'm going to try and figure out what rules apply. So we'll talk about that. And then what we'll do is we'll talk at a high level about some examples of common types of conflicts of interest that you might see out there. The understanding being that I think what I would like for you to take out of this is two things. Number one, how do we identify when there is or may be a conflict of interest? And then number two, once that identification occurs, what is it that we should be doing about that? And so the next little bit is going to be about that part one. And I think what you're going to get is the lawyer's favorite answer and the answer the client hates, which is typically it depends. And so one of the things I think I would say to you is a lot of this really is about being aware that there could be an issue and turning your mind toward it. I think where folks tend to get into issues is they step into something and didn't even realize that it could be an issue. So having that flag go up is very important. I also think that having that knowledge and understanding, as Maria said, conflicts are inevitable and sometimes not necessarily a bad thing, because it means you have people who are plugged into the community of the organization that you're serving. And so it's not so much about saying, oh, conflicts are bad, let's not talk about them. It's more of a sunlight is the best disinfectant. Let's talk about this. Let's deal with it, see how we're going to be able to effectively manage it. So it's not about avoiding conflicts as much as it is about managing them. So what is a conflict? I'm going to read you, I think, the best definition I've ever found, because you're not going to find, at least in the Canadian corporate law I'm familiar with, a nice crisp, this is the definition. So typically we would look to cases, and the best one I've found says, a conflict of interest arises in any situation where a director's duty to act solely in the best interests of the corporation and adhere to their fiduciary duties is compromised or impeded by any other interest, relationship, or duty of that director. So let's unpack that. Let's plain language that. What does that mean? It means when you're a director, you have a responsibility to act in the best interests of the corporation you're serving and not in your own interests. That's what we refer to as a fiduciary duty. And so the idea is that if there's something that prohibits you from making those decisions in the best interests of the company that you're serving, if there's something that prohibits you from putting the company first, then that would be something that we would look at as a potential conflict of interest. Where do these duties come from? Well, the sources of these duties, as I mentioned, come from three things. The first is the statute, so that would be your legislation. The second is the common law, which in Canada and most other jurisdictions, I would say, except those that have civil law, and I'm not sure there's anyone on this call who's in one of those jurisdictions, although maybe if there's someone from Quebec, that would be an example. But in any event, judge-made law that interprets the common law gives us more clues about what we ought to do, how to spot a conflict of interest. And then the last is what I would call constating documents of an organization, which is a fancy word for those important constitutional documents. So that would be your articles of incorporation, your bylaws, your shareholders agreement. So in those three things that I talked about, the statute would be your corporate law statute that applies to your company. And so typically corporate law is dependent on the particular jurisdiction where you're located. So in each Canadian province, they have their own form of corporate statute, the Corporations Act, Business Corporations Act, things of that nature. If you're a federal company, there's the Canada Business Corporations Act. The commonality is each of those statutes will set out a procedure for if there is a conflict of interest, here's what you ought to do, and we'll get into that later. So that's one source of conflict of interest. Common law, again, as I mentioned, is judges over years applying these statutes and saying, okay, in a particular situation, we think that a conflict arose or didn't arise, and here's why. So if you are looking to a lawyer for a legal opinion, one of the things that they'll often do is try and find cases, or case law, we call it, that interprets these laws and applies them to practical situations. And hopefully we can find something that's close to whatever situation you find yourself in. Last piece is, as I mentioned, the constating documents. And typically where I would look is your bylaws, because most companies' bylaws will have something in them that talks about directors and officers avoiding conflicts of interest. And so to the extent that you're on the board or you're involved otherwise with board activities, you're going to want to be familiar with what those documents have to say, because they too will set the goalposts in terms of what you need to do or ought not to be doing, as the case may be. So let's talk now about common types of conflict of interest. And some of them are quite obvious. And the most obvious one is what we would call at law self-dealing. So what self-dealing means is when the company is entering into agreements, there's someone on the other side of the table, and self-dealing is you. So that would be a situation where you are buying or selling things from, or offering services to, or loaning money to the company. And so I think for most people, self-dealing would be a pretty obvious example of a conflict of interest. And if you look at the conflict of interest laws, they typically would say that if the person who's on the other end of the contract or agreement or arrangement is either the director themselves or an entity in which that director is also a director or officer. So if you're on a board of another organization and that organization is dealing with your company, that could be an example. And then the last one, and where sort of the gray areas often arise, would be if the director has a material interest in whoever it is that's a party to a contract with the company. And so oftentimes you'll see that arise where someone maybe has a family member or a close friend or some other connection, and they are not themselves party to the transaction, but that other person with whom they have a material interest, that's not a defined term. And so you need to look at specific instances to determine whether or not there is that material interest. But that would be another example of self-dealing. Some of the other ones and other examples of what can constitute a conflict of interest are perhaps a little bit less obvious. And so these can arise in situations what we would call taking a corporate opportunity. What is that? Well, the famous Canadian case about that I think took place in the 60s was there was a fellow who was on a board of a surveying company. And while in the course of being a board member of that surveying company, the company had an opportunity to bid on a particular arrangement or agreement. And what happened was the board member and the company didn't bid on that opportunity, but then the board member separately on their own decided to take the particular contract and was awarded it. And that was found to be offside and an example of a conflict of interest because they were using knowledge that they had gained in their capacity as a board member to a particular company for their own benefit. They were taking that opportunity from the company. So that's another example of a conflict of interest, and sometimes perhaps a little bit less obvious than some of the ones that we would typically see. Another type of conflict of interest that you would see would be competition, and again, seems relatively straightforward. This would be the sort of thing where perhaps I am a board member on a couple of different companies, and they tend to have interests that might align. And we would try not to do that, but sometimes it happens. And so in those situations, I could be placed in a conflict position where there's two companies that might be interested in the same particular contract and bidding on it. That makes it difficult for me as a director to sit on both companies, because if I do something for company A, that could be to the detriment of company B and vice versa. So that's an example where competition could give rise to a conflict of interest. But this list is what we would say as lawyers, a non-exhaustive list or a non-closed list, meaning a conflict of interest could be any type of thing. And just because it's not something that I've mentioned now or something that's been recognized before doesn't mean that it couldn't be a conflict of interest. And it goes back to, I think, what Maria was saying at the outset, being aware of the issue, understanding at a principle-based level what might be a conflict of interest can be very helpful, because then ultimately you get to a point where you're able to spot these and effectively manage them ahead of time, rather than picking up the pieces and deal with them afterwards, which is certainly not ideal. And before I throw it back to Maria, I would say one thing that I am seeing more and more, and perhaps some of you have as well, is the idea of executive incentive-based compensation. And much has been written, and I don't know that there's any definitive answers, but to me, it's interesting. I guess what's interesting may vary to different people, but I think it's interesting. If you have a situation as a senior executive who perhaps may be an officer of a company to act in the best interests of the company, and your compensation is based on perhaps how the company's stock market price does executive-based compensation incent you to do things that may have an immediate value to the company and therefore your compensation that ultimately isn't in the best interest of the company long-term? Because we know sometimes the right decision is a hard decision. And so if you have executive-based compensation, does that place you in a position where you might be incented to make decisions that are in your benefit and perhaps the company's benefit short-term, but not long-term? And I don't know that there's an easy answer to that, but just an example of how there's really myriad issues here that could be walked through. So at this point, I think I'll turn it back to Maria, because now talking about identifying conflicts of interest, we could start to look at process improvements and things that can be done to effectively manage them.
Thanks, Andrew. Okay, I want to focus on 3 key areas where I really believe there are opportunities to improve the process of talking about and managing conflicts of interest. And I want to give you some examples, both good and not so good practices. So firstly, I'm going to talk about the process used for declaring conflicts and issues around documenting the board's due diligence that I've seen. And I also want to talk a little bit about training, especially for board chairs. So let's start with improving the conflict of interest declaration form. When you're appointed to a new board, usually as part of your onboarding process, you get a bunch of information. It used to be a big binder. Now it might be a login to a portal that has a whole ton of information. And you're asked to sign a variety of forms. And one of them may be a conflict of interest declaration form. And for many boards, you sign that at the beginning of your tenure, and that's it. In most cases, that form is very straightforward. It simply, it might have verbiage around the organization's policy, and then it just says, do you have a conflict to declare? You know, check the box, yes or no. If yes, there's space to explain. And then the board member signs it, hopefully dates it too, and that's about it. And while that's the most common form I've seen, it's not the best format. And I'd like to talk about a better format we could use. But first, I want to just mention what is not a conflict of interest declaration form. Because on some boards, members sign code of conduct documents. They're usually about a page. They list a bunch of behaviors that you're expected to uphold. And somewhere in there might be a line around, you know, something around declaring conflicts of interest. So having a code of conduct document is a good thing, but it's not the same as a conflict of interest declaration form. The other thing I've seen people hand me is sometimes you're asked to sign an oath of confidentiality document. It also might have a little bit of wording, extra wording around other behaviors. So again, an oath of confidentiality, that's a good thing to sign as well, but it is not a conflict of interest declaration form. So let me share with you a better format for these forms. And it usually has 3 sections. So the part that we're used to, the question, do you have a conflict, yes or no? That's still there. That's section 2. It doesn't change at all. But there's a previous section, like the better forms start off with a first section that asks you to first list all of your involvements, your current professional and personal involvements, both paid and voluntary, and maybe any business ownerships or any other personal relationships or professional relationships that are relevant to this organization. And then the second section is the having reviewed that or listed that, are there any conflicts, yes or no? And you add in, there's space to write any mitigating actions, and the board member signs and dates the form. So they fill out the first 2 sections. And I want to just stop before we go on to the 3rd section, because I know right now some of you may be thinking, well, why is that necessary? Why is that first section necessary? The organization already has my resume from when I was appointed or came onto this board. But I want to, especially in the public sector, I want you to be careful not to assume that, because sometimes members are appointed to boards by stakeholder groups or in the public sector by a legislative process. So your resume that was used for the appointment process may not have been shared with the organization that you're on. And sometimes when board members come onto a board, they're asked to provide a resume, but often it's more of a brief bio and a picture for the website is really all you're asked for. So even if you've provided a resume, listing what's relevant to this organization on the declaration form is important. And it's not just what's on a resume. So for example, my spouse's employment. That's an example. It's not on my resume, but it might be relevant to this organization. Or maybe I have a part ownership in a business, a local business that my son or my daughter or my in-law or my sibling owns. I'm not, if it's your children, you're probably a silent partner. You just gave the seed money and you don't think of it at all as your business, but you're listed on those documents as a business owner. So you don't think of that necessarily. Or say you have a close personal relationship with someone within the organization. So for me, for example, thank you, Claire. So for example, my neighbor is the CFO of a Crown corporation. And so if I was appointed to that Crown corporation, I would put on, hey, by the way, your CFO is my neighbor. Or, your head of finance is the godmother to my children, or whatever that personal relation is. We all have them. So anything that might be relevant to this organization would be that. And it's beyond what's on your resume. So let's move on to the third section. So the board member has done their duty on the first two sections, but the third section is where the chair reviews what's been written, and it's a sign off for the chair. And usually it's fairly simple, but it also, the chair can choose to discuss anything that's noted with the board member just to ensure clarity. And they sign and date the form, and maybe they document if the discussion was held and maybe any other mitigating actions that have been agreed to. So let me give you like a real example of what this looks like. A good example that I came across. So there was a board member in an organization, and they had written in that their spouse was an engineer that worked for a large firm. So that one's a real one. And that organization was known to bid on projects with that organization in the past. Their son had been a client of the organization, and they also listed that they are also on the board of a not-for-profit that actually is located next door to this organization. So, the chair reviewed that with them, and in talking about it, and there's no conflict with the neighboring organization, different sectors, different work, but just that they were neighbors. So there was like some property considerations. So the chair reviewed and discussed this with the board member, and they talked about, their son being a client of the organization in the past wasn't an issue. Being on the board of the neighboring organization isn't an actual conflict, but it's good to know. And it was clarified by the board member, like my example before, that the spouse is not involved in any way with project bidding or project selection. So there wasn't a direct conflict, but they agreed that if an infrastructure project were to come up in the future while she was on the board, that she would recuse herself from the discussions and the voting, that topic area, if that firm put in a bid. So this kind of format just helps to change the dynamic and the discussion around conflicts of interest. And most importantly, it provides an opportunity for discussion, and it makes sure the chair is aware of and knows what has been written on the form. Too often I've seen these forms are filled out, they're put in a file in the corporate secretary's office, and no one ever actually looks at them. So before we go on to change anything, I just another important thing before we get off of this is to improve the process is to have all board members sign the documentation, the form, annually. Not just when the board member begins, because one of the weaknesses I've seen with that process is, let's face it, when you first start on a board, you may not have even gone to your first meeting when you're asked to sign those documents, you don't really know the details of that organization. You don't know its significant involvements. You don't know its financial involvements or its risks. You don't know what its strategic issues are or what future projects are thinking. You don't actually know. I mean, it's easy to check no right that second and say, oh, I'm not in conflict. But you don't know. Now, policies usually say that the onus is on the board member if something comes up to raise the issue or to update their form as necessary. So, but even so, doing the form annually as a standard practice is just a really good practice and helps keep conflict of interest issues fresh and helps give us opportunities to talk about it over and over, and the policy is fresh. And one last thing before we move away from the declaration form is to also make sure that the process, you include in the process any others who are privy to board discussions. So I'm thinking here of any advisory member or non-voting members that you've invited to the board or to a committee. So for example, audit committees sometimes invite professional accountants to provide advice as an advisory position, or having an investment expert on your investment committee. So these people as well should sign a conflict of interest declaration form. And also any positions such as the corporate secretary position that is privy to board, that's working directly for the board, they should complete a declaration form that's reviewed and signed off by the chair as well. So second, let's talk about the processes for demonstrating the board's due diligence, because you know, I've seen a lot of, this is where some things really don't happen as well as they should, or as well as the policy might imply that it should. So first of all, of course, is to be clear in the minutes. All board and committee meeting minutes should document record any members declaring a conflict of interest, but also what the resolution was. So, and whether they left the meeting for any portion of that, the discussion or the vote. And basically, it should say the time they left and the time they came back in the room. And I definitely read a lot of bad minutes that don't do that. So the minutes might show that a member declared a conflict about a topic, but it doesn't actually document what, if anything, was done, or whether the individual recused themselves from the discussion or not. Sometimes they'll say to me after, oh, well, it's part of our policy, so they automatically did. And it's like, yes, but it's not documented. Can't assume that. And many board minutes do not actually document the vote. It just says pass. The motion just says pass. So there's really no way to know if the individual voted or not, if they were in the room. So I've also seen boards use an approach where the chair asks at the beginning of each meeting, does anyone have a conflict? And this is good so that board members think about the agenda items and am I conflicted in any way? Nothing wrong with that process. However, what happens is at the beginning of the meeting, it might be, you know, Maria declared a conflict with agenda item 5. But then when we get to agenda item 5, there's no documentation. It doesn't know what's been done. So we don't know if the person left the room or not. We don't know how it was handled. There's no documentation about the resolution, just that at the beginning of the meeting, I declared, and I don't know what happened there. So I want you to remember the onus is on you as a board member. Board members are responsible to make sure the minutes accurately document what happened. So at every board meeting, board members are asked to approve the minutes from the prior meeting. And it's so rote that board members barely pay this attention. But you need to take this seriously because approval of the minutes is your testament that they are an accurate representation of what occurred at the meeting and become the final record. So if something ever does go amiss and there's later scrutiny due to a fraud investigation or an audit that I might do, or I'm sure a legal matter, we can talk about that. Well, you can't blame errors in the minutes on the corporate secretary or the recording secretary. It is the board member's responsibility. So let me give you a good example of an individual themselves going above and beyond to ensure minutes were clear. So there was no perception of conflict. So in this case, the board member declared a conflict of interest as their spouse worked in a clerical role for the organization being discussed. And the minutes documented that the board members discussed this and felt that there was no conflict and that the board member should stay. But this individual chose to recuse themselves after providing a few comments about relevant background about the organization that might be useful to the board's discussion, and then remove themselves from the discussion and the voting. And all of this was documented in the minutes. So I think that sets a really good tone and for that individual, especially about choosing to err on the side of caution whenever there's a potential for a perception of conflict. And I think it's really important that the board as a whole also take that approach and demonstrate the highest ethical standards and choose to always err on the side of caution if there's any perception that a conflict may exist with a board member. Even if that board member feels that they can remain independent and bring an unconflicted perspective to the decision, it's not about, again, remember, it's not about the individual. It's about protecting the integrity of the board's decision making. So that's really important. And I'm just going to wrap up with reminding that, boardroom members do not come pre-trained on this. And so it's very important to have a good onboarding process about all aspects about your board, but especially about what does conflict of interest look like for your organization, your particular organization. Otherwise, when they're filling out that form, checking yes or no, they're just basing that on whatever they're familiar with from their past experiences on boards. And other boards, it can be very different from one type of organization to another. So their past experience may not be relevant to your organization. Make sure you have a good process on this. And also, we need enhanced training for new board chairs, because while the onus for declaring a conflict of interest rests with the individual, it's the board chair who kind of has that extra responsibility to ensure it's managed appropriately during the board meeting. And they have to, so when they come on board, make sure they're trained on the organization's policies and practice and how they're to be managed, and also how to handle stick handle issues and maybe what potential conflicts could occur. So I'm going to turn it back to Andrew to share with us what can happen if a conflict of interest is not managed appropriately and what improvements should be made from a legal standpoint.
Thank you very much, Maria. And as I get into that, reflecting on some of the things that you have said and looking at some of the comments, I absolutely agree with the comment about practicing and demonstrating diligence, showing your work. And I think that's very helpful, because from my perspective, if we get called in to look at something afterwards, the first thing I will say is, what did the minutes say? Because if it's not in the minutes, it didn't happen. The minutes are the record of the meeting, and you're not in a very favorable position if you need to argue that something was done that was not reflected in the minutes, particularly because, and maybe it just might be the boards that I'm on, when the minutes of the previous meeting are read, it would be slim to none chance that anyone is ever going to raise issues with those minutes. So I think people just tend to assume the minutes are accurate. And so if you haven't had that entered into the minutes at first instance, and then memories fade, you're not putting yourself in a good position. So certainly that documentation aspect is important. Another piece that I think is important to share, thinking about some of the things that have been said, is the idea that when we talk about disclosure that's required in a conflict of interest under corporate law, there's an important qualifier, and that's a material contract or an interest in a material transaction. So what that means is, if we're looking at a situation where someone's going to buy someone else a cup of coffee, of course, perception is important, but we need to ask ourselves always, is this a material interest? And I absolutely agree that discretion is the better part of valor. And when it comes to wondering whether you should disclose or not, you always need to err on the side of over disclosure. Very, very little bad can happen from that. That said, I have seen, and oftentimes where we get involved is where someone's looking for an advisory opinion about whether or not something is a conflict of interest. And one organization I can think of that we were working with over the summer, they had an issue such that everyone was declaring a conflict and the board was unable to pass any business on a particular issue that was an important issue. And so I think it's a fine line, and it's one of those on the one hand, but on the other hand, situations. But certainly, at least flagging the issue for discussion around the board table is something that should be done, but also recognizing that there is that materiality qualifier. And so the interest that you may have may not necessarily be a disqualifying interest. And so that's, I think, something that should be considered as well, because what you don't want is a company unable to conduct business. That will actually get into another good question that I saw in the comments that I'll address in a moment. But to talk about what can happen very briefly, because some of you may have experienced this, hopefully not personally. The hammers here and things we need to be aware of is I spoke earlier about the concept of a fiduciary duty. So your duty to act in the best interests of the company on whose board you're serving. And so if something is done in breach of that fiduciary duty because there has been a conflict of interest, that can result in all sorts of unwanted and unintended consequences. You can have a board member who's removed. You can have the company be required to do what's called disgorging its profits, which means any money it made, it has to be paid back. You can have shareholders and other stakeholders in the corporation bring a lawsuit for oppression against the company. You can have situations where the company is authorized to sue the conflicted directors. We would call that a derivative action. So all of these things can result from a breach of fiduciary duty. And so we should be aware that that's one example. You can have some court action. Another common example is that the contract would be what we would call voided, which means it's treated as never having existed. Again, not an ideal outcome, so we want to avoid that. I think something that's probably near and dear to a lot of directors, particularly where they're advising and steering a company through some difficult situations, is the concept that at law under the corporate statutes, but then also presumably under your company's bylaws, you'll see this. And there may also be insurance in place, director and officer or D&O insurance. There will be particular rules that need to be followed with respect to declaring a conflict of interest, such that if you don't follow those rules, you may be disentitled to claiming indemnification or compensation from the company for liability or harm that you experience by reason of having acted as a director. So what do? You make sure you follow whatever it is those particular documents require you to do. And so you would need to look at those documents in each case to know what's applicable to your particular organization that you serve. But what I would say is most of them track very closely what you would see in corporate statutes. And I'm going to get into that in the next segment, where we talk about how you properly manage from a legal perspective these conflicts of interest. So one other thing that we see, and I talked about this already, is to the extent that you have directors and officers insurance, some of these policies will have exclusions that do not provide cover in the event that the person who's experienced the loss, the director or officer, has failed to declare a conflict of interest or otherwise acted contrary to the applicable rules for conflict of interest. And so being cognizant of the fact that there may be compromised insurance coverage is another thing that we certainly want to be wary of. So that's the bad news, but let's talk about some of the good news, or at least the not so bad news, in terms of how we manage conflicts of interest. And one of the things that I think is important is we ought not to confuse the existence of a fiduciary duty with the requirement that you be perfect, because that's not what's required. What's required is that you act with a view towards best interests of the company, but a perfect outcome is not required. In addition to a fiduciary duty, directors have what's called a duty of care to the company to act reasonably and prudently as a reasonable person in the circumstances would. And as a function of that, that's not a standard of perfection. We have what's called the business judgment rule, which means that when we're talking about conflicts of interest, it's important to follow the rules. But with respect to decisions that you make generally, perfection is not required, and there is some discretion and leniency because the law doesn't want to discourage people from acting on corporate boards. So I think that's something to be aware of, and it fits into the mix in all this. Okay, so how do we manage conflicts of interest? Well, I'm going to take a few minutes to try to decipher what some of the corporate statutes, and I'm going to talk about the Canada Business Corporations Act, because I think it's fairly indicative of what your standard Canadian corporate statute, which is what I'm familiar with as a Manitoba lawyer, would have to say. And really, I think there's three key things. There's the concept of disclosing. There's the concept of participating in discussions and voting or not, as the case may be. And then there's the concept of what I would call ratification, or having some extra level of approval of the actions that were taken. So to unpack those things a little bit, important to note that these duties apply to both directors and officers. We've largely been talking about board members here, so directors, but to the extent that you are an officer of the company, these things would apply to you as well. And so I spoke earlier about what constitutes a conflict of interest that requires disclosure. That's that material interest, an interest in a material contract or a material transaction. So if that arises, then it's your obligation to make that disclosure either before or at the meeting where the matter is first discussed. So again, disclose early, disclose often. As Maria has said, and I think it's excellent guidance, make sure that that disclosure is entered into the minutes. And at law, it's not just a case of saying, I have a conflict of interest in sitting down. What the law requires is you need to disclose the nature and extent of the interest that you have. So that doesn't mean a 20-page tome about why it is you're conflicted, but it certainly means enough information so that the other people around the table and ultimately the minutes will understand at a high level the general nature of the conflict that you're dealing with. So that's the disclosure piece. So you've made the disclosure. Now what are you supposed to do? Can you vote, or do you need to not vote, and do you need to leave the room? And I think what I would say here is, again, sort of erring on the side of caution and understanding that a lot of the time conflicts are about perception. It may be that the law doesn't require you to leave the room. And in fact, we have what we would call avoidance standards, which say just because you were in the room, if you didn't vote on the decision and the board otherwise approved the decision and it was objectively fair and reasonable to the company, then the mere fact that you were in the room doesn't and took part in discussions doesn't create something that would be a disqualifying conflict of interest at law. I think my point on that would be, if you know you have a conflict of interest, why would you invite that potential outcome, invite that danger? It would seem to me the safer and more prudent aspect would be to simply leave the room during the discussions, especially if you know you're not going to vote anyways. I think to me that invites trouble and probably isn't worth the risk. So that's the idea of whether or not you ought to abstain from discussions, but what about the vote itself? And what the conflict of interest provisions in the corporate statutes would say is you're expected to not vote on the issue unless it relates to one of two things. One is that you are voting on something that relates to a contract of indemnity or insurance. So to the extent that you're seeking repayment from the company because of some harm that you suffered, you're specifically permitted to vote on that. You still need to disclose your interest, but you're still allowed to vote on that, and the law is clear on that. Another piece is with respect to compensation. If the board is deciding how much there ought to be compensation, and in assuming that other procedures are followed in bylaws, and being very aware of perception, because it may be that the law allows you to vote here, and it does, but you sometimes wonder about the outside appearance of that. But the law says that when we're talking about compensation, together with contracts of indemnity and insurance, those are two situations where you're particularly permitted to vote. But otherwise, the expectation and rule is that you won't participate in those discussions. You'll leave, and other board members will do what needs to be done. The last piece that I would talk about is that ratification angle, which is, again, you're entitled to be present and not take part in discussions if the contract is otherwise reasonable and it's approved by the board. Another layer of protection you can have is if the shareholders of the corporation approve that contract, because they're presumed to be an independent body. That works well for small, closely held owner-operated organizations. Doesn't work so well for large publicly traded companies, for example. So that's not always an option that's available to people. So high level, that's what the law itself requires you to do. Some of the other points here, just check the time here. Some of the other points here that we can think about and be aware of, and Maria has already talked about this, is the concept of putting policies in place. It's helpful for a company to show that due diligence was done, to show not just that the rules were followed, but also that there was proper training, that the directors were made aware that there was a process in place, that there was training, that there were consequences of non-compliance enforced. Having those rules and policies is very helpful because, again, they help keep these things top of mind, and that's often half the battle. You're converting your unknown unknowns to at least a known unknown, and that's sometimes one of the best things you can do to avoid these situations. Another piece, and this goes to a very good question that was in the chat, is asking yourself what hat you're wearing. And what I mean by that is corporate law 101. Think of it like a triangle. You've got your shareholders at the bottom. They have no duties to the company. They have fairly limited powers, except one very important power, and that's electing the board. The board's at the top of the pyramid, and below the board is the officers and the people who are hired as employees or otherwise contracted to do the day-to-day workings of the company. What can often happen is, especially in small, closely operated companies, all of those people at those three levels I just talked about can be the same. And so it's important to remember when you're making a decision, is this a meeting of the shareholders? Is this a meeting of the directors? Is this something other than a meeting of the shareholders or directors? So understanding in what capacity you're acting and appreciating that it is, at sometimes it almost seems like a legal fiction, but understanding which hat you're wearing when you're making a particular decision. And one of the things in situations where this would come into effect, it'd be important is, let's say we're talking about a situation where you are a particular stakeholder appointee. In Manitoba, for example, there are pension boards, and those pension boards will have stakeholder nominees that are allowed to serve. And the specific reason for so doing is we want people to bring a particular perspective or interest to the table. We want an employer representative. We want a labor representative. And so the mere fact that you are an appointee or a representative on the board does not create a conflict of interest. In fact, that is assumes and encourages you to bring the perspective of that particular group. That's why you're being asked to go and sit on the board. Where we draw the line, and again, this is one of those it depends situation, is it is entirely acceptable for me to bring my personal perspective on issues. That's why I'm supposed to be there. But I'm also expected to demonstrate professionalism and understand that, notwithstanding that a particular decision might be really helpful for the stakeholder group who appointed me, at the end of the day, I still need to decide and do what's best in the best interests of the company and be prepared to defend that. So it doesn't mean that I need to decide against the group that acted me in every single situation, but it means that I have to at least have a defensible basis for deciding why it is I decided what I decided. So saying I took the perspective that I have from this particular background that I have in mind is acceptable, understood, and encouraged, but making a decision and saying, this is clearly not the right decision, but I'm making it because it's in the interest of whoever appointed me and detrimental to the company. That would be an example of something that would be offside. I think we can all agree that there could be any number of situations where the answer is not as clear. And so I think what I could say to you is you try and keep those principles in mind and understand that there may be particular situations where the answer isn't as clear, and perhaps you need to seek advisory help on that. And that takes me to another point that you can think about is if you're not feeling comfortable about something, at a certain point, it may be a good idea, if not incumbent on you, to seek independent legal advice about that. And you may have access to the organization's solicitor, but keep in mind that their job is to advise the company as a whole and not individual directors. And so when there is a potential conflict of interest or a dispute about the extent of a conflict of interest, and your views could be potentially adverse or different than that of the company as itself, then there would be an understanding that while you might want to get independent legal advice, the company may or may not provide funding for that. But one of the benefits of doing that is, we talked earlier about due diligence. Nobody's expected to uphold a standard of perfection. Showing that in good faith you consulted and obtained a legal opinion that said you could do this, this, and this. It's not a get out of jail free card in the event that that opinion was wrong. But it certainly helps you demonstrate good faith, and that good faith is what we're really looking for when it comes to a fiduciary duty. One last piece that I would say is, as a director, one of the rights that you have is to dissent from a decision, to put on the record that you don't agree with the decision and here's why. And why would you do that other than because you feel really strongly about something? I mean, you think it's the right thing to do. Well, one of the reasons is, as we know, directors can, in some instances, be personally liable for decisions that they make in their capacity as directors. And the scope and extent of that is certainly grist for a future mill and a different presentation, probably one that you've heard before at some point. Having that dissent entered in the record is a way for you to argue, that wasn't my decision. I specifically said no. It's on the record. I didn't form a part of that decision. I don't want to be responsible for this. And that's going above and beyond just voting no or abstaining. It's actually explaining, I'm not doing this and here's why. So those sorts of things can certainly be helpful if you're then looking at some sort of responsibility for a decision that was made by the board contrary to conflict of interest procedures while you were on the board. So those would be some of the points that I would touch on and share with you in terms of managing conflicts of interest. And so I think that sort of concludes my prepared remarks. I know we have a few minutes here. Perhaps we should open it up now to questions from the floor.
Would anyone like to ask a question to our guest speakers? Alan?
Well, great presentation, Andrew and Maria. That was awesome. I work in a nonprofit sector. We work with boards all across Canada, and what's often used to control the conversation, decisions, and people is the gray area of perception of conflict. So there's no conflict, but we're going to paint someone in the corner and say, well, you can't participate because you're on that board, or you have family there, but we're recruiting these people because they're involved in the community. But now they're how do I differentiate that with our clients? And as we work with them and identifying what's really an issue and what's not, I know dysfunction's often an issue, but it's the egg and the, anyways. So I don't know what your position is on that, but I would love a bit of insight.
So I'll take a first crack at that one. It's tough because with perception, ultimately someone's making a subjective opinion, and opinions are what they are, and it's very difficult to convince someone that their opinion is wrong. So I think from my perspective, what I would say is, first and foremost, satisfy yourself that there's no conflict of interest, and be prepared to explain why that is. Because separate and apart from what a particular stakeholder might be saying, if your actions are ever called into question in a legal or a regulatory proceeding, you want to be able to defend what you did. And then the question, I suppose, is if you've done that and you explain that to the person and they still think there's an issue, at a certain point, I think I can do no better than tell you that sometimes reasonable people disagree and unreasonable people maybe disagree as well too. So I don't have a good answer for you, I think, other than you make a decision that you think is defensible, you document that, you have the dialogue, and if the person still has an issue with that and they're not satisfied with what it is you've done, at a certain point, I think you have to just agree to disagree. And I'm not really sure that there's much else that you can do, unfortunately. I don't have a practical answer for you on that one.
Yeah, and I know that this comes up all the time, and I certainly worked on audits where this has been critical. I can think of, I just want to give you an example of everything we talked about in the question about the representational boards, and it does happen a lot in the public sector. I think we're one of the worst for that. But this was an audit I worked on with Ontario Auditor General's office in Ontario. And it was where a public sector organization where the board was comprised of the mayors of the municipalities affected. And there was also some others, but you had the mayors of those municipalities on the board. And so in this case, obviously this is an inherent conflict for the mayor, in that they have a fiduciary duty when you're on this organization, no matter what, no matter, as exactly what Andrew said about whatever stakeholder group appointed you, now that you're sitting on the board, you're there to bring the perspectives of that group and your personal perspectives and bring that information to the table. But when it comes to the decision making, and at the end of the day, you must do what's in the best interest of the organization that you serve on, the board you serve on. You're not just there to fight for your stakeholder groups at all costs and make sure they get their way and all, like that is very dysfunctional. So that you got a whole other, that's a whole nother session on the dysfunctionality of the board.
Yeah.
But so that's really, it happens on nonprofits too. I know, and especially now Manitoba. Manitoba is a small province population wise and smaller communities. Everybody is interconnected somehow or another. So that's why I actually think it's better to make sure the minutes are clear and say, we talked about, like if the board talks about it and the board says, no, okay, you know, your brother-in-law owns a photocopier company that we're buying from. We all know that. Can we make a decision? Do we need to, like, I think showing the board did something is really important. But there's the thing about the mayors, there's such an inherent conflict. When you're elected to be mayor, you have such a strong inherent fiduciary duty to fulfill that role. You should not be on the board of this other organization. So what happened in the real example, of course, you had one mayor who again, got a legal opinion, they could stay, they had a very direct conflict, they were whatever. So they stayed but couldn't talk or vote, is what it was, the legal decision that was got received. But of course, they sat there the whole time like this, they rolled their eyes, they created, see, that's why to me, there's all the legal things, but it's about the people behavior. And so what happened was it stilted the board, it created really dysfunctional, everybody's uncomfortable. And anyway, I'll leave it at all the bad examples, but let me tell you what happened as a result of that audit is that board no longer exists. The organization was dissolved within about a year of our audit, and the organization was incorporated into a new larger, it's a transportation organization, and it's very clear in the board composition in the legislation now that no municipal representative or employee can be appointed to that board. So they got rid of the problem by changing the legislation and the constituting documents. So there's a million audits, like, so that's Ontario, there's a BC one, especially when you have deputy ministers or ministers serving on board, like it's just not cool. That's why I said, let's just get rid of it. But, you know, I can talk about it behaviorally. Andrew talks about it, what the legal things are. So I know it's a big issue.
So Maria, I thank you for that answer. I see one other question I'll touch on very quickly. I appreciate that we're slightly past time, so people are rolling off, and that's understood. Everyone's busy. Someone had asked a question about what rights minority shareholders have, where it appears that there's a conflict of interest that no one seems to be doing anything about. So I think, in short, the answer is unfortunately not much. The board is typically elected either through an appointment process that's set out in a shareholder agreement, if that's the case, a statute if it's a public company, or perhaps bylaws if you have bylaws. But the general rule is majority votes, majority gets to pick who the directors are. So if you're a minority shareholder, you're sort of along for the ride. So in a situation like that, one perhaps unsatisfactory result is vote with your feet and see if you can disassociate yourself from the company, which is sometimes difficult to do in private, closely held companies. Another approach that you can do is, I spoke earlier about the oppression remedy. That's a situation where anyone, including a minority shareholder, can bring an application for relief if, for lack of a better way of putting it, the board or the company is acting in an unfair or prejudicial manner. So those would be the two sort of typical things that I would think about, understanding that different people may be in different situations with particular remedies. And I think, unless there was any other last minute questions, we had some takeaway slides, which I'm going to very quickly throw on the screen here, and hopefully here I've wrestled technology to the ground and you can see them. I think I'll do a bit of an audible here and say that, given the timing that we're at here, there we go. There. Given the timing that we're at, Claire, I understand that these slides can be made available as sort of a takeaway point for attendees.
We'll post it on the website with this recording.
So Maria, I don't know if there was anything you wanted to add to your slide. I'll happy to let you speak to that briefly. And I've got one slide after that, which is quick as well.
Yeah, no, go ahead. I've said all those things, so I wanted to put them down there, and I added in an Auditor General's report that we had done that talks about some of these issues. Now, it's related to the topic of the audit, but you might see in there, you'll see best practice in there, and you'll see what these organizations did and why it was an issue around minutes, around the form, etc. So I'll pass it to you, Andrew, to go on to your slide.
Thank you very much, Maria. Yes, this oversight report is great, because to the extent that a lot of the things we've been talking about are theoretical, there's some good concrete guidance there. My slide, I think I would say, is pretty consistent with the comments that I had as well. Oops, there it goes. So I think I would commend you to look at these. I don't think there's anything there that I didn't talk about today, so it could be a nice take-home point for you. So thank you from my perspective, for everyone for attending today. I appreciate the opportunity to do this, and I'll throw it back to Claire.
Me too. Thank you, everyone, for attending. I really appreciate this is one of my favorite topics now. Really, boards struggle with it so much. So thank you very much, and thanks for all the participation.
Thank you. Thank you, Maria and Andrew, for this great presentation, for sharing all your knowledge and insight. We truly appreciate it. And I'd like to thank everyone who attended here today. I hope you can join us with our next presentation, which we do have scheduled on October 25th. I put it in the chat line. If you'd like to visit our website, you can register there. And that topic will be ethical dilemmas in times of turbulence. And the guest speaker will be Mark Tasse. So I hope to see you then. And I hope everyone has a wonderful afternoon. Thanks again.
Thanks, everyone.
Bye-bye.